Hello guys, welcome to the LawPutra YouTube channel. Our today's topic is the Rajasthan Tenancy Act 1955 Section 42, which talks about general restrictions on sale, gift and bequest. My name is Jagannath Kulkarni. Let us see the overview of this act, the Rajasthan Tenancy Act 1955. It is covered in 19 chapters. Just see the chapters. Preliminary, then khud kasht, this is important concept of this act, then classes of tenants, various classes have been given, then conferment of rights on certain subtenants and tenants of khud kasht on payment of compensation, then restrictions on holding land which is in excess of the ceiling area, specified ceiling area. Then primary rights of tenants. Then devolution, transfer, exchange and division. Then surrender, abandonment, extinction and surrender of tenancy. And then improvements. The further chapters are about the trees, then declaratory suits, then determination and modification of rent, then payment and recovery of rent, then ejectment, then grant of land, then grove holders, then daradars and thekadars, and then procedure and jurisdiction of revenue courts, and finally the miscellaneous. So these are the 19 chapters this act is covered. Total 260 plus sections are involved in this. What we are talking about today is it's chapter 4, which talks about the devolution, transfer, exchange and division, and part 3 of this chapter which talks about the transfer of tenancies, remember. And section 42, which is our today's topic, it talks about the general restrictions on sale, gift and bequest. So this is the section containing various clauses. Clause A, which has been omitted, then clause B, clause BB and finally clause C. Let us understand this section. This section says the sale, gift or bequest by a khatedar tenant of his interest in the whole or part of his holding, it shall be void. So this section talks about what can be void, and it will be void if such sale, gift or bequest is by a member of scheduled caste in favor of a person who is not a member of the scheduled caste, or it may be by a member of a scheduled tribe in favor of a person who is not a member of the scheduled tribe. And then such sale, gift or bequest, notwithstanding anything contained in clause B, which is above, it is by a member of one more scheduled tribe is given, which is Saharia scheduled tribe, in favor of a person who is not a member of the said Saharia tribe. So this section typically is a sort of negative section, we can say. It talks about when such sale, gift and bequest will be void. So when it will be from SC to non-SC, ST to non-ST, or Saharia to non-Saharia. So these are the things of voidable, or not even voidable, it is the void sale, gift and bequest. Now let us see the implications of this section. Because of this, the sale, gift and bequest by this particular category or community of the society cannot transfer this so as to make it agreeable or make it enforceable in law. And that is why Lok Sabha held the debate on 27th of February 2013, and it has been discussed that there is a need to amend section 42 of this act, Rajasthan Tenancy Act 1955. And what is the purpose of? To facilitate sale of land which is owned by people belonging to scheduled caste community. And this was the purpose of this debate. And then two other castes for the welfare of scheduled caste. So this section 42, which was supposed to be or appears to be detrimental to the interest of scheduled caste, it needs to be modified, it needs to be amended. And this was the reason behind this Lok Sabha debate on 27 February. Now let's see the implications of it. What happens is section 42B has been added. After section 42, 42B has been added, which talks about declaration as valid of these sale, gift and bequest. So this is the section, and this section contains the proviso, and under that proviso 4 clauses are there, A, B, C and D. Now let us understand this section. This section says where any sale, gift or holding before the commencement of the Rajasthan Tenancy Second Amendment Act 1992, Act number 22 of 1992 was void on account of contravention of any of the provisions of clause A of section 42, which we have seen just when it is from the SC community to non-SC community. As it stood before the said Amendment Act of 1992, such sale, gift or bequest may be declared to be valid by whom? By the collector or any officer or authority empowered by the state government in this behalf on an application made to him or it within such time and in such manner and on payment of such fee and penalty as may be prescribed. And the proviso says such sale, gift or bequest was otherwise legally valid and in conformity with the provisions of the laws for the time being in force except those contained in clause A of section 42 as aforesaid. Remember, it was from SC to non-SC. And the parties to the sale or bequest comply with all the terms and conditions which may be prescribed by the rules or by any special order or general order. And the payment is made of such premium or penalty as may be prescribed. And the applicant undertakes to pay urban assessment levied at such rate in accordance with such manner as may be prescribed. So if these four provisions have been fulfilled, then such sale, gift or bequest can be declared as the valid one. Now case law, this is one very important case law related to section 42 of Rajasthan Tenancy Act. This is about the Rajasthan Housing Board versus New Pink City Nirman Sahkari Samiti Limited and another. And citation is Civil Appeal number 1527 to 1536 of 2013 by Supreme Court. And this is the important or crux of this case. It says, in order to protect the interest of the scheduled caste persons, the society or other intermeddler or power of attorney holder shall not be paid compensation on their behalf, and the collector or LAO, that is Land Acquisition Officer, to ensure that the compensation is disbursed directly to the khatedars or their legal representatives as the case may be, and that they are not deprived of the same by any unscrupulous land grabbers, etc. And this is important case law regarding this. We also need to consider Article 46 of the Constitution, which talks about the state's duty to promotion of educational interests, economic interests of SC, STs and other weaker sections. We also need to consider Article 31, which has been already repealed, which talks about the compulsory acquisition of property, and also Article 31A, which talks about saving of laws providing for acquisition of estates, etc. And it talks about the laws which are inconsistent with or in derogation of the fundamental right. Then no law should be, there should be extinguishment of modification of any rights. It is given in subclause E of clause 1 of article 31A. So these are the important articles or important uh, case laws related to section 40 of the Rajasthan Tenancy Act. Thank you.